The constitutionality of Section 84, subsection 12 of the Electoral Act continues to divide opinions after President Muhammadu Buhari expressed reservations over the section while signing the electoral bill into an act of parliament. Well, joining us to shed more light on the legality or otherwise of the provision are lawyers and public affairs analysts Daniel Bwala and Inibere Effiong. Thank you both, gentlemen. I mean, it's good that we have lawyers to help us understand the legality or otherwise of this issue. Let me start with you, Inibere Effiong. Where do you stand on the argument that Section 84, subsection 12 subjects serving political office holders to inhibitions referred to already in the Section 40 and Section 42 of the 1999 Constitution on the issue of freedom to associate and, freedom to associate?
Thank you. Well, the first point I want to make is that it is commendable that the Electoral Act has now been brought into existence. The new Electoral Act has now been passed, so we now have a new Electoral Act 2022, which is what should have taken place even during the 2019 elections, but for what I can describe as the complicity between the President and the National Assembly. Now, my position is clear. The contentious section, that is the section of the Electoral Act that the President is claiming that has offended the Constitution, I don't think it is necessarily a question of infringement on freedom of expression or freedom of association under Section 40. My view is that when the National Assembly enacts in the new Electoral Act to the effect that political appointees cannot participate either as delegates or aspirants during the convention or congress of parties, that runs contrary to Section 66 of the Constitution, Section 107, again, Section 137, and lastly, Section 182, which prescribes the disqualifying factors. That is what disqualifies a person from contesting for a position of President of National Assembly, House of Assembly, President, and Governor, respectively, to the effect that the person shall not be eligible if he has not resigned or retired from office not later than 30 days before the election. What that means is that the Constitution is clear. The Constitution has set the requirements, the qualification and disqualification for contesting for public office. The National Assembly cannot, by the constitutional doctrine of governing the field, purport to add or subtract to the criteria set by the Constitution. So to that extent, the provision in contention is unconstitutional because the Constitution has covered the field on who is eligible and who is not eligible. And what I find more curious is that the National Assembly limited this to what they call political appointees. Again, that provision is not defined. Who is a political appointee? I presuppose that that is a reference to ministers, commissioners, and excludes those who are elected. So if the National Assembly is saying that it is important for those who are occupying public offices not to participate in primaries or be delegates at conventions of parties so that they will not use their offices to influence the process, why are they exempting themselves? Why are they exempting governors? Why are they exempting the president? Why are they exempting other elected public office holders? Why are they limiting it to appointees? So for me, this is an enactment that was made in bad faith. But I must also say that there are other provisions in the new Electoral Act 2022 that I had expected the president, if the motive is genuine, to also raise issues, not to stop assent, not to withhold assent, but to also express
for example, if you can hear me, just to bring in Mr. Bwala into this conversation as well, from what you have said, Inibe, some would say it's because perhaps the Constitution has made it clear and has made provisions clear for offices of the president, governors, and members of the National Assembly who want to contest elections, and that's perhaps why it's limited to political appointees. But Mr. Bola, let me ask you, to be or not to be, do you agree when the president says this contravenes the Constitution?
Well, thank you for having me. The provision of section, I think, is it 84 and sub 12, is partly right and partly wrong. The part that is wrong is the provision that says they cannot participate in voting. But the part that is right is restricting them from exercising their powers to vote. The part that is correct is restricting them from being voted. So let me put it this way. The amendment of the Electoral Act that the president seeks to have it expunged does not infringe on the constitutional right of political appointees. The spirit and the intent of the lawmakers is that political process should not be influenced to the extent that the whims and caprices of those who occupy public trust using the position that they occupy to influence the process to their advantage. And these political appointees in reference also affect the political appointees of the legislators, not just the political appointees of the members of the executive. The reason why the legislators and the key members of the executives are precluded is because they are participants in the final election. The provision of the Electoral Act, Section 84, sub 12, does not refer to the conduct of primaries. The reference is to the conduct of convention, that is pre-primaries, the process that produces the executives that will then conduct the primaries. Now, so the National Assembly would have said that a person who intends to run for office in the Congress should be precluded from being voted for unless he resigns, but should not be restricted from voting, because power to vote is as provided by the Constitution. But qualification to restrict your capacity to be voted for is a determination of both the Constitution and the Electoral Act in conjunction. Those who argue that because the Constitution has provided for qualification and disqualification, therefore the Electoral Act cannot in the circumstance vary the provisions of the Constitution, ought to take into account the fact that the Electoral Act was enacted as an enactment pursuant from the power of the Constitution that will guide the conduct of election. And so not every provision that provides for qualification or disqualification ought to be written in the Constitution before it can have the force of law. Now, you know that even the guidelines of INEC now can have the force of law, not to talk of the provisions of the Electoral Act itself. So in a nutshell, I believe that Section 84 sub 12 partly is correct and partly is wrong. So they ought to, in my view, rather than deleting it as requested by the president, they should rather amend that provision to say that anybody who is a political appointee and wishes to vie in the conduct of Congress should not be voted for. But that person has the capacity and power to vote for anybody.
All right, let me bring in Inebere Fiong. I wonder if you agree with what Mr. Bola has said, that that particular aspect of the Constitution should be amended in a way that would not allow political appointees to be voted for, not necessarily to vote, because, I mean, it's constitutionally guaranteed. But then again, what do you say to the notion that this particular section was intended to dislodge the president's appointees, believed to be nursing various ambitions towards 2023? Is it here or there?
2 points. Well, I think it will be trivializing the issue to make this about appointees of the president, because if you look at that section 84 sub 12, it does not say political appointees of the president. It says political appointees. And recall that I said that that phrase, political appointees, has not been defined. Who is a political appointee? Does it include, for example, a vice chancellor? Does it include heads of agencies? It is not defined. So it is not just about the president. Political appointee can also mean even people that occupy offices at local government level. And I have said you cannot say that regarding what Mr. Boala has said, I totally disagree with him. In 2003, the case arose. That is the case of Balarabe Musa and INEC, which was litigated up to the Supreme Court, now reported as INEC versus Balarabe Musa and others. That was a case where what is happening now, a similar thing happened. When the National Assembly, purporting to extend or expand the requirements for a body to be eligible to be registered as a party, added to the condition that the Constitution has already set out. Balarabe Musa, Ganifa Wemi, and now others went to court. And the Supreme Court made it clear that once the Constitution has set out requirements, stipulated what is needed and what is not needed, by the doctrine of governing the field, the tentative law, the indisputable law on that matter is the Constitution. You cannot add or subtract. So what I'm saying is this. If he agrees with me that by virtue of Section 66, Section 107, Section 137, and Section 182, that the Constitution has already set out and outlined the qualification and disqualification. That is when you are eligible and when you are not eligible. The National Assembly cannot add or subtract. It is not about their motive. No matter the nobility of their motive, the law is clear. But this is the point. This is the point. Why are we even having this conversation about whether political appointees should be allowed to participate as aspirants? If the intention, as I have said, is to ensure that they do not use the influence of their office to determine and unduly favor themselves in the process, why not expand it to include everybody? It shouldn't just be political appointees.
I think that's a good, because we're almost running out of time, Inibe, forgive me, but we have to manage the time here. Mr. Boala, very briefly, as you can, perhaps the fundamental question is, who are political appointees like Inibe has been trying to point out all along? Are they public servants? And if they are, or if they're not, are we not transporting privileges to rights? Because if they are appointed to serve, it's not a right but a privilege at the behest of the person who's appointed them.
Yes, political appointee in the context of Section 84 and Sub 12 does not require further explanation or definition. A political appointee is somebody who assumes the role he is playing by virtue of an appointment, other than by rising in the cadre or by an examination that he sits and writes and passes. So if you are appointed as a special advisor to the Deputy President of the Senate, you assume that role by an appointment given to you through a letter. And the Revenue and Mobilization has all of these details that relate to that. So a political appointee in the context of 8412 does not require any further explanation. It is clear, it is unambiguous, and it should be given the ordinary meaning that it deserves. Let me give you instances where qualification is not provided for in the Constitution, but in another enactment, and it works. Section 138 sub 1, A, B, and C provides for ground for which election petition will be challenged. Those provisions, I think, is only one or two that you can find in the Constitution that relates to qualification. But all these other ones comes from the Electoral Act, yet it has the force of law that can invalidate an election. So in other words, not every provision for qualification or disqualification ought to be written in the Constitution before it can have the force of law. Even as low as the guidelines of INEC can have a force of law in the context of election and election-related matters, because election is a sui generis.
All right. Thank you so much, both gentlemen. Lawyers joining us tonight on Newsnight, Daniel Boala and Inibere Effiong. Thank you.